This video will consider the facts and decision in Dura-Post Australia Proprietary Limited and Delnorth Proprietary Limited, particularly regarding the inventive and innovative step tests. Dura-Post and Delnorth marked the first time the test for an innovative step was considered by the full federal court. The Patents Act provides the definition of the word patent means a standard patent or an innovation patent, establishing our two categories. The main differences between standard and innovation patents are their duration, cost, and the threshold of their tests. These reflect the differences in their use. Standard patents provide the patentee with long-term protection and control over an invention, while innovation patents provide shorter-term protection and are ideal for inventions with short market lives or that might be superseded by newer inventions. The Patents Act provides that a standard patent must be novel, useful, and involve an inventive step, while an innovation patent must be novel, useful, and involve an innovative step. The inventive step requires consideration of the past art, and only satisfies the test where the invention isn't obvious to a skilled person or in light of common general knowledge. An innovation step, on the other hand, considers the same general knowledge indirectly, and is satisfied unless the invention makes no substantial contribution to the prior art. This case had to consider what the difference between the steps was. Delnorth had 3 patents for steel road posts, which were sturdier and more easily replaced than others on the market. They alleged a competitor, Dura-Post, was infringing their patents. Delnorth had registered its patents as innovation patents. Dura-Post argued that Delnorth's patents did not fulfill the requirements of the Patents Act to constitute an innovation patent. In making a decision, the court confirmed the primary judge's finding that, in accordance with subsections 7.4 and 7.5, the following elements should be identified and considered: the state of the invention, who the person skilled in the relevant art was and their knowledge regarding the art, the common general knowledge in Australia of the art, and whether the invention only varied from the prior art in ways that make no substantial contribution to the working of the invention. The full federal court also had to consider what constituted an innovative step under Section 7. Dura-Post argued that Delnorth's patents lacked an innovative step under Section 7.4. They argued the improvements and additional features described in the patents did not make a substantial contribution and made no advance over the prior art. Delnorth's posts were made of metal and featured a notch at the base to allow removal and replacement of damaged posts. Dura-Post argued these improvements relied on common knowledge and didn't represent a substantial contribution. The court rejected this argument. Relying on expert evidence as to the nature of the improvements, the court was satisfied that the improvements that made Delnorth's road posts sturdier and more easily repaired constituted a substantial contribution to the invention. They also reinforced the idea that the inventive step considers the body of common knowledge directly, whereas its direct application is excluded for the purposes of the innovative step, and as it is only applied to help consider whether a substantial contribution has been made by the invention. In doing so, the court also upheld the approach taken at trial to assessing innovative steps, which involved asking the following 2 questions. What are the differences between the claimed invention of the innovation patent and the prior art? And do the identified differences make a substantial contribution to the working of the invention? Finding Delnorth's patents represented an innovative step, the court dismissed Dura-Post's appeal, finding Dura-Post had infringed Delnorth's patents. In so doing, the court confirmed the innovative step test in Australian law. In summary, a standard patent involves an inventive step which requires direct reference to common knowledge. It considers all common knowledge and is only satisfied when an invention is not obvious to a skilled person. In contrast, an innovation patent involves an innovative step, which is a lower threshold than the inventive step. It considers only the differences between the claimed invention and the prior art, and whether those differences constitute a substantial contribution. Delnorth's patent for a more sturdy and easily replaced road post was considered innovative, as even though it would be obvious to a skilled person, it substantially contributed to the working of the invention. Dura-Post therefore infringed on Delnorth's patent and the appeal was dismissed. Thanks for watching.